And I'll start with you, David. We see the denials in the interview. We've seen that in the other case as well, our Ice Cream Man murder trial. And those denials, I think, speak loudly when taken in the context of all the other evidence presented by this particular witness. This idea that he did buy trackers. There were recording devices. We know he did all those things. So when you start hearing him denying, I tell you what, he continues to close in on him, this case.
Yeah, without a doubt. I see, look, we just got through the Murdoch case, and that was a case where he lied about substantial material things, and then we had forensic evidence on the phones to show it's a lie. And I look at this very similar in a sense that the defendant opens his mouth and starts to talk. It's against rule number 1. He's advised he has the right to remain silent, but they think they could outsmart these police officers, and when they do, they just don't know what the police have. And when they have that evidence to go against that's inconsistent with these statements, and then you have the motive evidence and the stalking, and it starts to mount up with no other suspects or leads, it really becomes a difficult defense for the defendant.
You know, Rich, what's interesting about this, on cross-examination, of course, the defense attorney, I thought did a solid job. She had a checklist she was going through about all the things they didn't do, leads they didn't follow, the investigators meeting. And at the end of the day, you know, it's fertile area for defense attorneys. But when you look at a case like this where right after a murder is discovered and 2 people are telling them to look at this individual, then you begin to look at this individual, and I understand confirmation bias, but man, you start getting this evidence piling up against the guy, it's natural to stay focused. Resources are not endless. You can't send folks on all these different chases of all these various leads. You focus on this, and continually you're trying to eliminate the guy, and you can't. I mean, that's just the way it goes.
I agree with you, Michael. And I think jurors don't buy this argument that there was a faulty investigation, that they should have investigated more people when they pin down a suspect and they have such a strong motive case and they have such circumstantial evidence. And I agree 100% with David when they catch the suspect in lies, when he starts talking to police and thinks he can talk his way out of it. And it does all close in on that person. And it's just perfectly natural for the police to focus. And the defense can cry all at once about how the investigation wasn't thorough enough, but they've got to give some other story for why this murder happened. And I haven't heard another story.
No, we're expecting, David, their case to begin tomorrow at some point. Vincent Correa was the last witness called by the state. An interesting choice. Let me ask you about that. I mean, we generally see the lead detectives called early in the case, and then you sort of flow from some of the information that they're providing. They called Vincent Correa at the end of their case, and he almost acted like almost a catalog for all the evidence they have against this guy. What do you think about that choice?
Yeah, I heard your comments in the earlier block, and I agree, Michael. Sometimes prosecutors lead with the overarching view, the macro view, the 3,000-foot view, and then it explains sort of how the pieces come in, because trials, as prosecutors, they're tough. I mean, they come in witness by witness, piece of evidence by piece of evidence, and it's the opening statement that maybe gives them a large picture, but sometimes it's the case detective that could do that. And they didn't do that in this case, but what the benefit is for the prosecutor is essentially he gets an opportunity to close. I mean, highlight the state's case over and again after the piecemeal admission of the evidence. And he's going to get to close again after he does his cross-examination of the defendant's witnesses. Well, then he gets to make a closing argument. In essence, he already just did that with this witness.
Yeah, no question. It acted for me like a refresher of the case. I mean, I was ticking off things that I didn't quite remember from, excuse me, weeks and weeks ago. All right, gentlemen, stand by. I do have to take a break coming up.